Our last speaker, before Webb wraps it up at the very end, is a great pleasure to introduce Lauren Sheets-Gerald. Lauren serves as the in-house counsel for the American Tort Reform Association, ATRA, based in D.C. Welcome back from the swamp as well. She manages the association's robust amicus brief program, co-authors the annual judicial hellhole report, manages the association's media outreach, and is responsible for tracking and analyzing all tort legislation at both the federal and state level. That makes me kind of tired just thinking about all of those activities. She joined ATRA in 2010 and assumed her current position in mid-2014. ATRA, incidentally, has been a great resource and friend of the Montana Chamber and of the Judicial Reform Initiative in particular. ATRA's kind of 100,000-foot view of the country, understanding where other states have pioneered judicial reform, I think has really eased the burden of those types of efforts here. So it's really a great pleasure to have you here and wrap up our day. Thank you. Please welcome Lauren.
Well, thank you to the Chamber for having me. I'm very excited to actually be able to make it to Montana this year. I was supposed to speak back in 2014, and I had to do it over the phone because of weather issues, so it's nice to be here in person. I also appreciate that I'm the last speaker of the day, and you all have had a lot of information thrown at you. It's been a great, very informative day, so I will try not to take up too much more of your time. But I'll touch on several issues, and I encourage you all to sort of ask questions throughout my presentation if anything comes up. I'm going to talk about things that several of my colleagues have already spoken about, but hopefully we'll go into a little more depth. And again, welcome any questions that you all might have. First, I just want to give a little more background on what exactly the American Tort Reform Association is, because I know some of you all might not be familiar with our work. We were founded in 1986, and we are the only independent national tort reform organization in the country, and we have a 50-state reach. So we really focus on relationships with state groups like the Montana Chamber, and we try and serve as a key link between the civil justice reform community and those state groups. We work to identify trends and problems with the civil justice system, such as activist state attorney generals, regulation through litigation, judicial nullification of tort reforms, and then abuse of consumer protection acts, just to name a few. So ATRA has four core activities. We have our legislative program, where we identify and monitor key legislative priorities. We develop policy solutions with our members and with allies on the ground. And then we work to provide legislative and lobbyist support to the state groups, and those working on the ground in the different cities and capitals. We have a media relations program. We try to be the first stop for the media on civil justice issues, and we really work to advance the civil justice reform message in the media. We also publish an annual judicial hellholes report every December, and we also have a blog that goes throughout the year. Montana has been on the watch list over the past few years, I think in 2014 and 2016, for punitive damages decisions and venue decisions, one which we just heard about. Luckily, you guys have managed to stay off the actual judicial hellholes list, so we hope that you all keep it that way. And finally, we have an amicus program, and we file amicus briefs around the country at both the state and federal level, working to both defend reforms that have already been enacted and to prevent liability expanding decisions. So I want to first give just a brief overview of the 2018 session, sort of from the national tort reform perspective. This year, we are tracking 261 bills around the country. By contrast, we tracked close to 400 last year, so we've really seen a significantly lower volume, which was expected because it's an election year in most states. There are shorter sessions, and legislators typically don't want to take up controversial issues during election years. 77 bills have been flagged as part of the trial bar agenda, so again, they've been even less active than our groups. For the affirmative agenda, Missouri has really been the hotbed of activity this year. We've seen transparency in private attorney contracting legislation introduced, legislation about seatbelt non-use, which Lee talked about earlier, Asbestos trust transparency legislation has been introduced in several states. It's a really hot topic issue, or hot button issue right now. E-discovery reform is being considered in Wisconsin, which would adopt the federal rules of civil procedure with regards to e-discovery requirements. Venue reform in Missouri in response to the BNSF case. Consumer protection reform in Missouri, and then a comparative fault bill in Oklahoma. So that's just sort of a quick view of what's going on around the country. As far as the defensive bills, like I said, they haven't been too active, but they have been very concentrated in a few areas. And we expect in a similar agenda next year. They've sort of outlined 4 areas that the trial bar really wants to attack right now. They want to eliminate arbitration completely, regardless of the fact that this is a federal issue. They're working to eliminate arbitration clauses in consumer contracts, employment cases, and in sexual abuse lawsuits. They are also really targeting employment law and looking to expand liability in this area with equal pay bills, wage per hour, and then just other more general employment discrimination issues. We're seeing a lot of attempts to enact state false claims acts with qui tam provisions, which is a troubling trend. And finally, the trial bar is looking to either eliminate or increase the limits on non-economic damages and punitive damages. I know Montana has seen this come under attack in their state court. The Supreme Court punted on this issue a few years ago, and I'm certain, as most of you all are, that this will rear its ugly head once again. Another tool for the trial bar in passing their agenda outside of legislature is looking at judicial nullification. The trial bar is really looking to take their fight to the courts to nullify these reforms because in recent years, there's been a wave of Republicans taking over at the state level. So they haven't been as successful in the legislatures, but they have been successful at the courts. So they're looking to attack reforms and get them nullified by activist judges. Our amicus program works to sort of defend against this, and we file cases at the state level really working to protect these reforms when they're being challenged on a constitutional basis. There are 2 areas that have been particularly under attack, and those are the limits on damages, and then also statute of repose and statutes of limitations. So that's sort of a look at what we're seeing from national level. Now I want to talk about a few reforms that we believe would be worth Montana looking at in the upcoming legislative sessions. First, I will address the governor's office. He says he is business friendly, but he does have a history of vetoing common sense reforms. So he will certainly serve as a roadblock, and he tends to say one thing and do another. Now, it was a very big win for you all to get the judgment interest bill last year, especially because he had previously vetoed that legislation, along with an appeal bond bill a few years ago. And those are typically seen as non-controversial, so it was a little shocking when he made that decision. He also refuses right now to support transparency in private attorney contracting legislation, which I'll talk about a little later because I think it's a very important issue that you all should consider. So first I'll briefly speak about seatbelt admissibility. My colleague Lee Mickus gave an excellent presentation earlier today, so I don't really need to go into a lot of detail. But this is a very important issue at ATRA. We have a dedicated task force to this issue, and it's one that we're willing to work with you all on if it's something you decide to do. As was discussed earlier, you all had a strong version of the bill in 2015 with SB 231, and basically it would have made evidence of non-use admissible in wrongful death cases and personal injury cases unless an intoxicated driver was involved. So we would hope to see similar legislation introduced again in the future. We believe that it's important for the jury to be able to consider all relevant evidence. There's no reason to keep something like this out. The next piece of legislation we think you all should consider is trespass. I spoke about this a few years ago, and it continues to be an important issue. This is a map of the states that have enacted some sort of trespass liability reform in recent years. So just a little bit of background. Trespasser is a person who enters another person's property without permission and without lawful authority. So typically, as a general rule, a landowner owes no duty of care to a trespasser, whether they are adults or children. There are some certain exceptions that are carved out, but that's the general rule. So what happened was, in 2012, the American Law Institute, which Harold talked about briefly earlier today, which was founded in the early 1900s, decided to dramatically change the law, or at least attempt to dramatically change the law. And the ALI issues these restatements on various issues, which are then available to the courts as resources and to be considered to be adopted. It becomes a law unless the state legislatures take action or it's superseded by statute. These ALI restatements are highly, highly influential with judges, especially in the tort law area, because tort law is oftentimes common law. They're perceived to be objective, and they're composed of the nation's top echelon of judges and law professors and practitioners, which is why they carry so much weight with the courts. The judges look to these restatements almost as if they are law and look to them for guidance. But their job is supposed to be to restate the law. It's not to create the law. Unfortunately, in 2012, they issued a new restatement, and in a section entitled Liability for Physical and Emotional Harm, they recommend that courts impose a duty on land possessors, to exercise reasonable care for all entrants on their land, including unwanted trespassers. The only exception to this new duty rule would be for harm to so-called flagrant trespassers, which was an entirely new term, and it has led to a lot of litigation because there was no definition for what is a flagrant trespasser. So what are the consequences for landowners and land possessors? I'm sure you all can guess, but more lawsuits, more opportunities for the trial lawyers to sue businesses, to sue landowners under this ALI restatement. So the trial lawyers have recognized that this is a way to increase their profits, and several of them have sort of carved out a niche practice in going after landowners. Larry Stewart, who is the former president of the Association of Trial Lawyers of America, which is also aka the American Association of Justice, co-authored an article in Trial Magazine, which is the trial bar's monthly magazine, calling this restatement a powerful tool for trial lawyers handling tort cases. And he described the restatement and talked about how it would be well advised for attorneys to review this and to use it, and listed it as one of the top 10 provisions of the new restatement that will benefit trial lawyers. He also characterized the rule as a major departure from the law and said that it was a change in the historical approach. So the trial lawyers knew what was going on. What's the solution? We suggest and have pushed legislation around the country that would codify the current law in the states. Basically, it would codify the historical common law approach and freeze the law of trespasser liability as it exists in Montana today, basically preempting the courts from adopting this new expansive view of liability. It would not take away anyone's current rights. It would not, involved in these cases, it literally would freeze the law as it is, so nothing would change. The legislation would also promote trespasser responsibility as well, and would follow the traditional rules that had been the case for 100 years. It also prevents the activist judges from green lighting lawsuits by intruders that would subject the landowners to broad new liability. As you can see from the map, we have enacted this legislation in 23 different states to date. And while it has been 6 years since this restatement has been issued, we're really starting to see more proactive legislation by the trial bar being pushed around the country, and we are starting to see an increase in bad court decisions, meaning it's really important to take these steps to prevent this increase in liability. The next piece of legislation that we would suggest Montana consider is called Transparency and Private Attorney Contracting. This is a map of all the states in dark. I apologize for the fuzziness. The states in dark blue are ones that have enacted this type of reform. And we feel that this is probably the most important reform that you could consider, given other legal issues that are developing around the country right now, which I'll talk about after going through what this legislation is. So transparency and private attorney contracting requires reasonable contingency fee caps and provides for transparency and accountability when states hire outside private attorneys. Typically, it sets a tiered limits on fees for outside lawyers and then a maximum cap of what those lawyers can receive. For example, right now in Kentucky, there's a bill being considered that sets tiered limits of 5% to 20% on awards of $10 million to $20 million, and then states that a fee shall not exceed $20 million regardless of the type of actions, the number of actions that are involved, the number of lawyers working on the project, and the different proceedings. It also importantly sets transparency requirements and requires that they provide detailed information to the public about how much money these trial lawyers are actually going to receive from litigation and through these contracts. We've had extensive conversation with Montana's leadership about this, and Attorney General Fox has signaled that he would be open to this type of legislation if Governor Bullock would sign it. To date, Governor Bullock has not been supportive. But since both are term limited in 2020, there could be opportunity, or there could be ways to work around that in the next session. 21 states have enacted this legislation, including most of your surrounding states, North Dakota, Colorado, Utah, Kansas, Iowa, Minnesota, and Nevada. So why is this important? Well, we're really seeing a lot of trial lawyer pushed litigation by the states. The Wall Street Journal's editorial board published a Pulitzer Prize-winning piece that revealed that politically influential plaintiffs' lawyers were shopping their ideas for potentially lucrative lawsuits to state AGs against these corporate defenders to friendly state AGs, who then hire the lawyers and expect generous pay-to-play campaign contributions down the road. So we really need to shine a light on the plaintiff's involvement in this litigation and push back against this approach. By providing transparency and making people more aware of what's going on, it will ensure that the policies and the litigation that our state prosecutors are pursuing are actually in the public interest and not serving the financial interest of the trial bar. I want to discuss what legal issues we're seeing right now that make this really an important issue. First, I'll talk a little bit about opioid litigation. The connection to all of your industries and manufacturing companies might not be obvious, but this really should be a concern for most industries and how this is playing out. Because once they've finished attacking the opioid industry, they will look for the next manufacturing industry to go after. It's not going to stop here. So our view is that the opioid crisis is a very dangerous and complicated public health crisis. And it needs to be addressed by elected policymakers, doctors, medical experts, and the scientific communities and law enforcement. And we must work to advance the interests of public health and safety. As you know, unfortunately, a number of states, counties, municipalities, they've all flocked to the courthouses and filed lawsuits demanding that manufacturers, distributors, and pharmacies pay for the cleanup of this problem. They're then hiring outside counsel to handle this litigation. And it's very similar to the tobacco litigation that we saw in the 1990s. The same players are involved, and they're employing the same strategies. For example, Mike Moore, who was the Attorney General for Mississippi back during the tobacco litigation, who hired notorious trial lawyer Dickie Scruggs to represent them in the tobacco litigation, is now leading the charge for all of the trial bar. This is the opioid litigation. What many people aren't realizing is it's very different from tobacco. First, opioids were developed to address a legitimate medical need. They require Food and Drug approval, and they also require stark labeling requirements and labels on them about the potential for addiction. And finally, the distribution of these drugs is closely regulated by the Drug Enforcement Agency. All of these things were missing with the tobacco industry. So the main issue from our view is the hiring of the outside plaintiffs' lawyers to handle these cases, because they're motivated by their profits and by the potential to line their own pockets. They don't care about the victims. The use of private contingency fee lawyers has taken off since the tobacco lawsuits the tobacco settlement because it was so lucrative. And so policymaking, we need to see a shift back, and policymaking needs to be about public interest in health and not about maximizing fees of the trial lawyers. The TPAC legislation helps with this issue and ensures that these public health interests are protected. Some of you may have seen that AG Sessions recently had made a statement about opioid litigation, and during that, and about the increased involvement that DOJ was going to have in this litigation. And during that presentation, he stated that the DOJ would not be hiring outside lawyers, that all of the legal work would be handled within the DOJ. So he recognizes the importance of maintaining focus on public health and not involving the outside lawyers. And we are really encouraging other state AGs and municipalities to follow his lead. We're also seeing a similar push made by the trial lawyers with regards to climate control litigation. We know that an industry-wide litigation is on the horizon, and the trial bar is soon going to unleash a multifaceted attack on this industry as well, similar to what we've seen with asbestos and tobacco. The primary claim this far is that the energy companies have misled the public about climate change, similar to how the tobacco companies misled the public about the use of tobacco. Therefore, the argument is following that they should be forced to pay millions of dollars in settlements. As Harold talked about earlier today, and Leland and others, the trial bar is extremely well coordinated, and they should not be underestimated. They will effectively employ their litigation playbook, the same one they use in all these other different areas, and use the same tried and true tactics that have been successful for them in the past. They're identifying a broad societal issue and casting blame on a very narrow set of defendants with deep pockets, and that are also more easily able to be painted in a negative light. They seek to further demonize these companies by going out into the public opinion and the media and doing a push there. And then they test their novel theories in plaintiff-friendly jurisdictions, oftentimes judicial hellholes, and then leverage high-profile events such as recent hurricanes and other events to galvanize those public opinions. This has happened time and time again, and unfortunately, they've been very successful. Once they experience success in a small area, they will then expand the litigation to the broader sphere and try it anywhere and everywhere. Some of the more popular and figures that have been on the front of this is New York Attorney General Eric Schneiderman and Massachusetts Attorney General Maura Healey. And they've really taken on the helm of this for influence with wealthy mega donors, and they whisper these directives in their ear. They file the litigation, they then hire the outside lawyers, who are also their donors, to handle the litigation, and then those lawyers receive millions of dollars in fees, which they then turn around and contribute to these AG's campaigns. Again, TPAC legislation sort of helps stymie some of this abuse, and at least makes the public aware of what is occurring. Finally, AG sunshine and transparency can help with the problems around trial lawyer advertising, which several other people have spoken about today. These trial lawyers, we see a role for the AGs in fighting back against trial lawyer advertising. Basically, you have trial lawyers and aggregators that are spending exorbitant amounts of money in the media and to recruit new clients for class action cases against pharmaceutical companies, in asbestos world, all different areas. The aggregators, which many people don't know about, they're behind the scenes, and they're conducting this research, recruiting their plaintiffs, and then they're handing those off to the trial lawyers. The advertisements, unfortunately, are having a very negative effect on people, and it's creating a public health crisis. These patients are seeing these doomsday ads on television and being scared out of their minds, so they're stopping taking their meds without consulting with their doctors. It's dangerous behavior, and it's causing serious injury. It also increases the litigation risk for the product manufacturers. Unfortunately, this advertising is protected by the First Amendment, so we're having to work and find creative ways to help stop this abuse. Some of the solutions would be developing model legislation. So you require disclaimers, disclosures, and complaint mechanisms to relevant authorities, including AGs. So when these ads are on TV, they would have to have some sort of disclaimer or disclosure about who's actually behind these. We also encourage people to meet with state AGs to sort of discuss this public safety angle. alert them about the fact that that patients are stopping taking their medication and as a result are suffering severe health consequences. Also let them know that these companies are taking personal data from private sources and sharing it with the aggregators and trial lawyers. People are being called on the phone by aggregators who have found out that they are taking these medications. They are then being read over the phone, very similar messages to what's included on the television ads, and then the people, again, are personally scared and they will stop taking their medication. State AGs need to know about this and recognize that it is a very big public health risk to their people in their state. Finally, the last thing that I want to briefly talk about, because it is an election year, is the wave that we're seeing around the country of trial lawyers really infiltrating the Republican Party. For years, it's not always been the rule, but typically, Republicans have been more business-friendly, more supportive of civil justice reform agenda, and Democrats were heavily supported by the trial bar, so they tended to oppose our agenda. With the shift that we've seen in these state legislatures and shifting predominantly Republican, the trial bar is really starting to spend millions and millions of dollars in campaign donations to get behind Republican candidates. And originally this was just a problem that we were seeing in the South, in states like Florida and Georgia and South Carolina. And these Republicans would get in position of leadership and then just block all of our bills. But we are starting to see that happen all over the country. And so it's just something to be aware of as we head into elections. We may need to look for non-traditional allies, and we also need to be more aware of who is accepting what money and make that known. Sort of follow the money trail to see who is supporting these candidates and make sure that we get that out to the public. We welcome any questions that you all have. It's the end of my presentation.
Thanks, Lauren. Questions? We got work to do, clearly.
Oh, yes.
This may be a really dumb question. What does non-traditional ally look like?
Well, that's a great question. It depends, and depends on the bill that you're running. But for example, with certain issues, we have found that Democrats are willing to work on certain issues. And if you can find ones that are sympathetic to different, not traditional subject matter, for example, with the seatbelt laws, you can find people who are interested in protecting. For protecting different groups of people. For lawsuit lending, for example, we've gone to minority leaders because oftentimes for lawsuit lending, minorities are often targeted by this funding and these abusive practices, and so we were able to partner with some of them on that legislation, whereas typically they wouldn't be open to hearing our message. It's just about getting creative and finding different ways and different similarities that might not necessarily be on your radar.
Well, with that, thanks again.
Thank you,
Lauren.
guys.
Appreciate it.